good afternoon, good evening, and is it morning in some areas? Probably so. I came on a little early so I could say my hellos to people before my guest comes. So let me just get in here. Hey guys. So I'm gonna say hello to the people in the chat and just give you guys some reminders and things like that. Um, I'm gonna wait. Then I'll tell you who my guest is going to be. Let's see here. Say hello to the people. Hey, Nakenya, C, Rhoda, Mac, Meditation and Healing, Nakia, Lady, Gemini, You Digging Me, Lady Earth, Shannon, Nova, Valerie, Lisa, Olga, Bird, Rhoda, Kayla, Lovable Leo, Forensic Tech Guy, Carolyn, Bree, Miss Texas. Ugh, it just jumped. It just jumped. Hold on. Tawana, Ivan, Impress, Miguel, Leona, I ride solo. I ride solo. I'm loving me. Pink Boss, Sandra. I think I got everybody. Jana, Good Design, Robin. There go my guest. My guest is here, y'all. Say hello to Mr. Joe
Hello.
Brody. Hey, Joe.
How you doing?
I'm good. How are you?
Okay. Wow. I took a look at all that stuff you sent me.
It's a lot of
Wow.
stuff, isn't it?
Yeah. I tell you this.
You're
What
breaking
I
up a little bit.
okay. Here, let me. How is that better or
It's better. It's better.
I
It's
don't know?
better.
Can you hear me?
Yeah, I can hear you.
All right.
Can you hear me?
Let's just got to stay by them. Yeah, I hear you fine. Yeah, I mean, I'm looking at these the motions by the government. One's 55 pages, the other's 40 some odd pages. It's the whole reason that you don't wait to the last minute to do stuff like this. It's crazy. It's really kind of it's really the very reason why I was saying, a month ago that waiting to the last minute to do this type of case is just it's nuts. There's no, it's hot. It's next to impossible to do all this work within a month or a few weeks. It's just absolutely impossible. And I mean, the lawyers are four lawyers are probably working 24 hours a day, 7 days a week to try to catch up. But it's going to be a hard job to do. I mean, so did you? I'm sure you've looked over all this fun stuff.
Yeah, and I wanted to, from a person who is in the law field, and not for any kind of legal advice, but more of your opinion in regard to some of the things that you have read in regards to the motions that was set from the government.
Well, one thing I thought that was almost comical that the government wants to. Let me see now. Where was this? At the they want to introduce newspaper articles about. I guess they had to do with his marriage to Aaliyah. That he. I mean, that's about as classic hearsay as you can get. You're right, and a newspaper article is evidence. And yet the government here at the end of this 55-page motion, they're asking for permission to use that. They're calling it relevant evidence. It's on page 35 of their government motion eliminate number 3. I mean, it's it means, well, it shows you two things. One thing it shows is that the government's really got some proof problems with their case, but it also shows you that they're just trying to sneak may be the wrong word, but just kind of overwhelm the defense and throw so many things at them that they might not be able to, come up with come up with a good argument as to each one of these. I mean, this is what they do. This is typical. This is what the government does, and this is why you need to be in there, get in there, a year early, and start bringing emotions to whittle down what they can say and what they can do, and what witnesses can testify to, and what type of evidence that they can present, so that this doesn't all come at you at the last second.
I have a question. With Bill Cosby case being having precedence of some with that bad acts.
Oh yeah, prior bad acts. Yeah.
On it, will you think that will play a role on this?
No, I mean that was a state court case. This is obviously a federal racketeering case, and federal racketeering RICO cases are infamous for being for allowing very, very broad evidence, because what the government says it's trying to do is prove the quote unquote criminal enterprise. And so they say, well, we got to bring in all this evidence of all these other crimes and all these other unrelated offenses to show that there was a criminal enterprise, that was a continuing, and it's the way that the RICO statute was designed. That was always designed to go after mafia families, and mafia families would always have, you'd have all these different crews, and they'd be doing all the little scam here and a murder here and an extortion here, and but it would be part of the same enterprise. And so they were allowed to bring in all this evidence about these enterprises, and that was an effective tool for going after the mafia, New York mafia or the Chicago outfit. But it was, now what they're trying to do here is just take a basic, what's alleged to be a basic, statutory rape case, and turn it in and use the RICO statute in order to bring in all this bad, all these unrelated offenses and prior bad acts in order to really, well, they say prove the enterprise, but in reality, it's just a dirty, Kelly up, just to make him look like a really bad guy. And, now the jury won't like him, and will believe he did it and convict him. For example, one thing here that's just insane. There's this supposed, what was it? That where his crisis manager, for lack of a better word, goes in and tells him, I know this clerk. They call it his attempted bribery or bribery of a Cook County clerk. Comes and says, "Hey man, I spent $2,500 to get inside information from this clerk." I'm sure he says the second part of that's not in there is going to be, so I need you to give me the $2,500 back, reimburse me. And but this is just this crisis manager talking to Kelly. They have no evidence that the $2,500 was ever spent. They don't have evidence of who this clerk was. They don't have evidence that there was a burner phone. They don't have any of that. All they got is this guy talking to Kelly. It could all be, it probably is baloney. It's all probably just a scam, a con.
But Joe, there's a live that he did, and he said on that press conference that he doesn't work for R. Kelly. He worked for Greenberg.
Well, that could very well be. All I know is that you put some scam artist. I don't know this guy, so.
No, he's a scam artist. He's been convicted scam artist.
Okay, well,
okay,
you take this guy who's a convicted scam artist, and you put him in a room with a very rich man, and the first thing that's going through his mind is, how can I scam some money off of this guy? Oh, I'll tell him I got an inside guy. You give me $500, I can get some information out of him. And it's just as likely that happened as it being the other way around. The problem is that now there's no time. This should have been litigated. There should have been an evidentiary hearing to determine whether or not there's any evidence or reason to believe this actually happened. And or if it was a scam, to decide whether or not this evidence come in. There's no time to do that now. And so it's going to be done just kind of on off the cuff. And it's a real shame because it's very important evidence. It goes back to that the 2008 sexual assault case where Kelly was found not guilty, and they're trying to bring stuff about that and too about the supposed jury tampering. But when you look at the documents here, or at least what the government's representing in these motions, all that is that the same guy or somebody, I don't know, maybe somebody, but another con man coming in and telling Kelly, "Hey, man, I know one of these jurors. Let me see if I can influence him. Let me see if I can tell him you're really a good guy. You're not like this." Now that's hardly jury. First of all, that's hardly jury tampering. But second of all, there's no evidence that anything really occurred. There's no evidence that juror was actually influenced. There's no evidence that this guy actually knew the juror. All they have is talk. They don't have any solid corroborating evidence to back any of this up. And it's really a shame. And now I see that they also disclose these experts with this last minute DNA stuff, which is troubling because DNA is it's a powerful tool, but it's also based on statistics. And DNA analysis can be right and it can be wrong. If it's done properly, it can be very correct. If it's done improperly, it can give you very garbage in, garbage out. And there's no time for Kelly to get his own private DNA expert to look at this and look at the DNA, look whether or not it was properly analyzed, whether or not it was properly handled, whether or not there was any contamination. Remember, that was a big issue in the O.J. Simpson case, where there was cross-contamination of DNA. So there's no time. He can't get his own expert. I mean, hopefully the defense will be jumping up and down and saying they can't just bring up DNA at the last second. We have no time to get our own expert to challenge this. So, and then they want to bring in another psychologist to testify about how witnesses, victims, why they sometimes stay with their quote abusers or how they cope. I mean, that's insane. That's ridiculous because everybody reacts differently, and no psychologist can tell you for sure how a certain person is going to react in a certain situation. So they're just trying to deflect here, proper, what's going to be very devastating cross-examination of these people. Hey, if you were abused, why'd you stick around? But
there was one part where it was saying that they don't want the certain accusers to be interviewed, cross-examined.
Cross-examined. Yeah, I saw that they want to limit the cross-examination of some of these people, and that's a very there's two things. Some things they can't. I mean, there's what they call the rape shield law, which means that a sexual assault victim cannot be questioned about their other, sexual activities. Just because you had sex with one person doesn't mean you consent to the sex with another, but that's the law, and that's black and white law. But what the government wants to do here is go further and really limit any meaningful cross-examination about these people's not just sexual behavior, but just behavior in general.
Like lying.
Yes, exactly. Because that's how, and that's what they want to use that witness for, the psychiatrist, to say, well, victims lie, because they've been abused, which is insane. Because that's for the jury to decide. You don't need, if the government wants to argue that the person lied because they were so traumatized by the abuse, that's their argument. But you can't bring in you shouldn't be able to bring in an expert witness to testify about that. That's a question for the jury, and or I think there's one person where that person has some very strange religious beliefs and had a
That's Demetrius, the one who who's supposed to be the one that got the fake ID.
yeah, okay, well. Yeah, there was somebody that had a religious. What is it? I think that's. Let me see here. Preclude the defendant from cross-examining regarding religious belief in Rule 6, Rule of Evidence 610, which is not what Rule 610 is for. What they're saying here is this person believed that they had a religious experience in Kelly's presence.
In the bathroom, supposedly.
Yeah. And that they don't want, and then that person, began to speak in tongues or something, and they don't want to be, they don't want to be able to cross-examine. This has happened with Kelly, so why some of the events that he's being charged with were going on, and they don't want to. They want to try to stop the defense from cross-examining about that. That's. I mean, that would be if you have a witness to a crime and he all of a sudden has a religious experience and starts speaking in tongues in the middle of the crime they're supposedly witnessing. I think the jury should hear that to determine whether or not that person's a credible witness.
Yeah,
that's not a religious belief. That's the person's having some sort of breakdown. But
breakdown, exactly.
Yeah, but they're trying to, and the problem is that this is all being thrown at the defense in the last days before they start picking a jury, and it's going to be difficult for each one. Let's put it this way: I could teach a law school class on every one of these different motions, or they got 10 different or 12 different motions and sections of these motions. In each one of these motions, you could do a law school class in each one of these. How is the defense going to be able to properly go through all the transcripts and all the statements and all the evidence and properly put before the court all of the ins and outs and law involved in each one of these issues? It's going to be a Herculean task. I don't know that anybody could do it. I mean,
but my question is, why did they had 2 years to submit this stuff? I'm talking about the government.
The government. Well, that's what the government does. But what you do as a good defense lawyer would be you don't let them do this. You're filing motions, attacking the. I mean, people have known about the broad outlines of this testimony for a long time. And if they had gotten a lot of this discovery earlier, they would have known about the specifics of it earlier. And then you start filing motions saying, I want to, a motion to eliminate. I want to be able to question the witness about this event. I want to be able to question the witness about, about the breakdown. I want to be able to question the witness about the religious event. I want to be able to question I want to be able to keep out anything about jury tampering, because this is just two people talking. There's no corroborating evidence. You can't present evidence which is unreliable.
If it wasn't a crime committed, so you don't know if the crime was actually committed.
Right. I mean, just two people. Somebody says, "Hey, I got a guy and give me some money." That's not reliable evidence. Unless there's something to corroborate it, like. You have the money that was passed. You have, they did it by either there's evidence of the money being passed or evidence of contact with the juror or something, to corroborate it. Other than that, it's simply not reliable. And so you would have been able to file a motion early on to keep that out. You would have been able to file motions to on the rape shield statute to kind of determine the outlines of it and say, well, why I can't talk about, the sexual behavior. I can talk about, how they were, not actually the behavior, but how they went about it. In other words, if this person had a similar relationship with kind of with another person that was similar to where they were, seeing everything with the doing what they did with Kelly with another person. That would be relevant. That would be an exception to the rape shield statute. Or I mean, there's just so much in all these motions, and that's what's getting me is that all this should have been gotten into months and months ago, and there should have been a series of hearings on all these, with actual witnesses being called and testifying, and getting to the bottom of all this. And it's not. There's not, and it's just going to be next to impossible. I mean, we're going to find out how when the judge starts ruling on these motions. Like if the judge lets the newspaper articles in, then everything's coming in. It's nothing's. I mean, so you're gonna find out. I mean, there's been a lot of criticism about this judge that I've heard, but she could be a very fine judge. I don't know. I've never had a case or seen a case with her, but how she rules on these motions is going to tell you about how good a judge she's going to be, how fair a case it's going to be, because a lot of the stuff that the government's asking for here is just patently ridiculous. Like the parents, right? She said they don't want them to testify about the parents, but you have cases where the parents are actually bringing their daughters over to be with, dropping them off with Kelly.
Mm-hmm.
So, okay.
Mm-hmm.
So, if a parent's dropping the child off with a rock star, you kind of give you an idea that person's probably of age, because what responsible parent would drop their minor child off, right?
And leave, yeah.
So, it would be, but the government doesn't want them getting into that, and that's something that should have been brought up in a much earlier in a motion by the defense if they were allowed to. I mean, all this stuff is.
Hold on, John. Hey guys, can we cut it out with the language in the chat? Thank you. Okay, I'm sorry.
Okay, I can't hear what they're saying, so.
No. It's they're typing in. So.
Oh. It's really. Well, I mean, this is what the government. I promise you that this is what the U.S. attorneys over there were thinking when they're watching, when they were watching Greenberg just doing absolutely nothing for years. They were sitting there. They knew all this stuff, so they were preparing, and they knew that they were going to drop it at the last minute, and them like a bomb at the last minute. Because why shouldn't they, right? If the other guy is going to give you it's going to be a hockey game, and the other guy's not going to have a goalie. I mean, you're going to sit back and say, okay, I'm going to wait till almost the bell. I'm going to hit the puck into the goal, and that's going to be the end of it. So, I mean, that's what they were planning on doing. I can't blame them for it. It's a winning strategy, but it's really too bad that they let them get to this. That they let it get to this position. The defense, the Greenberg let it get to this point. I mean, I'm looking now. When I think I talked to you, there were only like 70 or 80 documents filed. Now we're up to document 136.
Yeah, it's a lot going in now, right?
Yeah, which is right. I mean, but it should have been at document 136 a year ago. So it's really a shame. A man with his resources and. His ability to get really good and dedicated people working for him, working really hard to get to do this, and he's going to get this. He's not going to be able to take advantage of the resources he has to fight this. For example, the whole thing about the 2008 case. I mean, he was found not guilty. The government is not bringing the juror that at least I can't see from these motions. They don't seem to be bringing the juror to say, yes, I was influenced by a representative that was sent to me by Kelly, and I would have voted to convict him, but for this influence. They're not doing that. And without that evidence, they shouldn't be allowed to go into the 2008 case. And that should have been brought up, a year ago, because everybody knew about that over a year ago. That it's not being brought up until a week before the trial, a week and a half before they start picking a jury, is criminal. I mean, it's really criminal. I really feel bad for the guy. I mean, I don't know how he's going to get a fair trial. I really don't. There's just too much here. Each one of these motions should take a day or 2 days of hearing to really go through it and get to the right decision and get to and meet out what can and can't get in. There's just no way to do it in the shorter period of time. And this judge has said she's not continuing the case. So, the whole purpose of RICO, I don't even know if this is a proper RICO case because, this is, there's case law out there that says you cannot use the RICO statute in order to turn a state court crime. You run of the mill. I mean, I hate to say it that way because rape or murder is a very serious crime, and it's very. But to take what's referred to as a run of the mill state crime like rape or robbery, burglary, murder, you run of the mill everyday state court case. And turn it into a federal racketeering case. You can't use RICO was designed to go for the mafia and organized crime. So, but you can't really pervert it to go to take a regular everyday state court crime and turn it into a federal case like they're doing here. And so that would have been the first line of attack. And if that motion was granted, then a lot of this evidence that they're using, other crimes evidence, would not be relevant because they wouldn't have a racketeering enterprise that they would need to establish. So it's just really a shame. I mean, I that's all I can really say. I mean, I could talk about the technicalities of all these different allegations, for hours because they're fascinating legal issues. But it's the big picture here is that, hey, why the big picture is that there's just no way to give each of these issues the proper attention it deserves in the little bit of time that there is. There's not. I mean, and that's really the crying shame. And because you got a government with unlimited resources, they can do it. They could put, if the government decides it wants to put 100 people working on the 100 law clerks and paralegals and FBI agents working on assisting the prosecutors, they can do it. The snap of a finger, they can do it in an hour.
But then that makes it unfair.
The state, the defense doesn't have that ability, and It is unfair because they can do this. They can dump everything at the last second and have somebody prepared to deal with each and every issue individually. But there's no way the defense can do this. It's just overwhelming. It really is overwhelming. That's why you got a defense got to start early and break it down into there's an old saying that you ask a question, how do you eat an elephant, right? Well, one bite at a time. One bite at a time, right? So you got to start taking those bites a long time ago, in order to be able to deal with this elephant. There's no way that they can eat this elephant this quickly. It's just not possible, and that's really a crying shame because, he's a man that has the resources to have done this right, and now he's not going to be able to. Let's take this. Kelly's. I'm looking at some of the stuff here.
You looking at some of the questions?
Well, I'm looking at some in this motion that they did, memorandum of law, and they talk about.
I was going to wait to the end to start, asking some of the questions that they have in the chat. So
no, Kelly's effort to obtain child pornography, right? I mean, in order to do that, this should have been challenge, because anytime you're getting something on the internet, somebody's saying, "Oh, I looked at his a computer and there were these searches for these weird pornographic websites." Okay, fine.
But it wasn't his computer. It was
Right.
her
That's exactly my point. You have to be able to prove that the person that you're accusing of doing this was actually on the keyboard, typing these searches in there or going to these websites. And how are they going to do that? Well, they don't have they don't have Kelly's testimony, but they don't have anybody's testimony that it was Kelly doing it. And
she's saying that his direction that he told her to do.
Okay. Well, that's a problem for them. I mean, the great thing was, well, if he told you to jump off a river, top of a building, would you do it? He told you to jump off a bridge, would you do it? I mean, you're going to these supposedly illegal websites. And, just because, like I said, just because somebody with a motive to lie or to fabricate, says something doesn't mean it's true. And that's why you have the hearing on what's called reliability. There's a rule, I can't remember off the top of my head. I think it's Federal Rule of Evidence 106, 104, I think 104, 106, something like that, that says that unreliable evidence is excluded. And if something is just somebody with a motive to fabricate saying something, that's not reliable. So you have to have a hearing on its reliability. And sometimes that's an evidentiary hearing where the witnesses testify in advance and you get a transcript and, the judge rules on credibility and that type of thing. And the defense has got a chance to cross-examine that witness before they ever get in front of a jury in order to, to show that it's unreliable. So the jury doesn't even get to it. And that they don't have an opportunity to do that. And that's what is crazy. That's what's really a shame here. But go ahead, go to the question.
You're breaking up now.
Oh, I'm sorry. Okay,
your phone is acting up again.
Okay, how's that? Am I okay now?
Say something again.
How about now? Hear me now?
It's still kind of choppy.
Oh, I don't. That's the internet.
There it is. You better now.
Okay, all right. Okay, why don't you go ahead with some of the questions?
All right, let me go up on these questions. I'm gonna put it on the screen so you can see the questions too.
Okay, all right. See what you got here.
All right, let's see. The first question is from Dom K. It says here, ask Joel, how does he think they did not specify or show actual communication between R. Kelly and the John Does? And ask Joel, does he think the judge will approve the opposition's request? Well,
in a motion in limine, they don't really have to, give the specifics. That's why you try to have a hearing where you make them break it down into the government tries to be vague as possible, and the defense's job is to make them be as specific as possible during the hearing. Unfortunately, in a racketeering case, because they didn't get, because Greenberg kept them, according to what Farinella told me, Greenberg kept them from filing a motion to challenge the use of the RICO statute. In racketeering cases, they let in almost everything. I mean, it's ridiculous, but they do. And so my guess would be, since the racketeering statute's going to be used, that the government's going to be allowed to get a lot of this stuff in that really wouldn't come in a normal run-of-the-mill, sexual assault or statutory rape case, which is the reason why there's those cases out there that say you can't use the RICO statute to turn a run-of-the-mill state court crime into a racketeering or federal crime, because they realize how powerful of and unfair, really, and how powerful of a tool a RICO is in convicting people, and so it was really designed for another purpose. So unfortunately, I think a lot of the stuff that really shouldn't get in is going to get in because they're being allowed to use the RICO case because the RICO statute because Greenberg wouldn't allow Farinella and so on the other and the other young lady, forgot her name right now, to challenge the use of the RICO statute in this case. So it's
but it was too late to do it now.
yeah, no, there's no way you'd get a motion to dismiss it now. It's way too late. It's way too late.
Okay, next question is what is a 404B motion?
404B. 404B is prior bad acts. It allows you to bring in somebody's uncharged bad acts in order to into a case. But
you have to prove that it was actually a bad act, right?
Well, yes, but they don't allow mini trials on that. So it's pretty. Once it's allowed in, they can give very general evidence about it. That's why you have usually have an evidentiary hearing on 404Bs. But it's also very limited in what you're allowed to use it for. It should be. It's, for example, to prove motive, modus operandi, method of operation, lack of mistake, things like that. So if somebody commits, like modus operandi, to say if a guy commits an armed robbery, saying the same words and using the same weapon and the same face mask 4 or 5 times, that's his modus operandi. You could use the uncharged acts to prove the one act, or if that's one example of a 404B. So lack of mistake, intent. If somebody claims that what they did, they shot a person, but they didn't mean to. The gun just went off. It was a mistake. It was an accident. Yeah, okay, that's fine. But if you have evidence that they shot 5 other people, well, you don't have 5 accidents. So, it will be allowed to show lack that it's not an accident. 404B motions are generally for that. In this case, unfortunately, because they're allowed to use the RICO statute and you have the racketeering element, 404B becomes extremely broad, and you're almost allowed to use almost everything because it would be to show a conspiracy, a racketeering enterprise, and that's the exception they use, and that way almost everything comes in. And it's really a shame. This is the argument that you have to make to the jury is that look at all this other stuff is out there, but that doesn't mean he did the offenses he's charged with. But you have to be lucky and get a very, very good jury to do that. It's just I'm sorry to say this. I feel like I'm the bringer of bad news, but this is what happens when you wait to the last minute, when everything happens at the last minute, and that's not Farinella's fault. It's not I forgot Natalie's fault. It's not it's not the other 2 new lawyers who have jumped on this thing and are probably working 80 hours or 25 hours a day. It's not any of their fault. It's Greenberg's fault. This is that nothing happened for all this time when all this should have been litigated over the years that they had to do it. Why Kelly was sitting there in jail. It's really sad. It's really sad. It's sad. I think that everybody should get a fair trial. If they're guilty, then they're guilty. If they're not, they're not. But at least they should get a fair trial. And it's going to be extremely difficult at this point.
All right. The next question is, Joel, what is your thought on the fake crisis manager that was hired by Steve and now is in the case as a witness, saying R. Kelly asked him to bribe?
Yeah, that's sorry. If that comes in, that's going to be that's a real shame too, because I was reading in these motions about I thought that they had something here, some corroborating evidence. Right now, all they got is a con man, and setting a guy up for $2,500. If that gets let in, that's crazy. You know, I think that's a travesty, because when you look at the when you read what the quotes that the government puts in there from what was said and how it was done, I mean, to me, it looks like the obvious con. It looks like just an obvious out and out guy trying to scam $2,500, and he should not be allowed to testify, especially if he was hired by Steve. Then there's no way he should be allowed to testify, because he wasn't Kelly's agent. He was Steve's agent. Unless they're going to charge Steve too, he should not be allowed to testify. But but of course now he's saying that he's probably saying now he was working for Kelly, but now you've got a guy with two diametrically opposed stories. So
there's a video showing he said it in a video, on a live video, that he does not work for Kelly.
Yeah, well, that's good. I hope that the judge, if they do allow him to testify, I hope the judge will be allowed to allow him to be cross-examined on his on his inconsistent statements and hurt his credibility. But I really hope that that type of evidence is not allowed in, because that evidence is just simply, unreliable. It's unreliable, and it's not evidence of a crime either, to tell you the truth, because there's no evidence that anything actually occurred. Just because somebody said they did something doesn't mean that they did it. And
they have the receipts, the checks, and all that kind of stuff.
Yeah, how about the guy he bribed? Bring him in.
Bring him in.
Yeah, where's the guy? I mean, this is the FBI. They should be able to find the guy he bribed. There's not that many clerks in Cook County, so they should be able to find the guy he bribed. There's a burner phone. They should be able to, to find the burner phone. Bring something in to corroborate it. But if they don't have anything to corroborate it, and they let this guy testify, that's really, I think that's unfair.
Okay, next question says, she says, since you're not acting as an attorney at this time, does he have enough empathy to send the lawyers some case law to help them fight?
Oh no, I don't need to send them any case law. He's Tom and Natalie and these other two, they're good lawyers. They know the law. They know the law. The question is, it's just so overwhelming, that even if there's not enough time to put together good arguments on the. For example, let me just give you an example. The average we used to take is, if there was one complex motion, like a 404B motion, prior bad acts, we would estimate it would take 50 hours to properly do that one motion. There's not 50 hours left, and you've got dozens of that type of motion. So it's just not enough time, So they don't need my help. I think that they're so probably working so hard. They're probably so focused on what they're doing right now. I think they don't need any interruptions. they just got to try to do the best they can in a really bad situation that wasn't of their creation.
Okay, next, what about the people with fake IDs?
Oh, you're talking about the Aaliyah?
There's two. There's three people. Well, two. Fake IDs.
Yeah.
There was one young lady that gave a fake ID. Actually, gave a fake. She showed a fake ID when she entered the court. Court. She said they said she was underage, but in that case, you had to be 18 to be in the courtroom, and she was in the courtroom with a fake ID. Well,
then that's that's evidence that should be used to, impeach their credibility. If they're showing fake IDs, that reflects on their credibility and their testimony, so they'd be able to question on that. The Aaliyah one is interesting because, we know that he got the merit. They have the marriage certificate, and they have her birth certificate, but they can talk about a fake ID, but they don't have it. So they're just conjecturing that there was a fake ID.
So they don't have the fake ID?
No, because didn't see it. I think that they're just conjecturing that there was a fake ID that was used, just like they said. They're conjecturing that he flew from Atlanta to Chicago, married her, and flew back to Atlanta to do the concert, and they're using the newspaper articles to prove that. So, so the same thing. I think that they're just saying, well, he got the
I
the
thought
marriage
they
certificate.
actually saw the fake ID, so nobody actually seen the fake ID at all.
Except probably except what they're saying is the clerk that issued the
But
marriage certificate.
shouldn't they take a picture of it?
No. You just you got to. If there's a question about age, they'll make you show an ID when you get a marriage certificate. But like when I got married in Cook County, my first and second time, and when my wife's my first and my second. We got a marriage certificate. Well, the second time I was already an old man, but the first time, nobody asked to see our IDs. We just went in and applied.
You didn't have to show any ID. I know here in Georgia, you have to show an ID.
No.
And we had to have a driver's license. You couldn't
No.
just show any kind of ID here. You have to show a
No.
driver's license.
We just fill out the application, swear to it, go in, pay the fee, and they give you a license.
Oh.
So. And they certainly, if they want to see an ID, they don't make a copy of it. The guy just looks at the ID and says, "Okay," and that's it. So I don't think they have the actual ID. I think what they may have is the clerk saying that. Well, I remember seeing an ID.
No, but it's not the clerk. It's the Demetrius guy is saying that he got a fake ID.
That he got a fake ID, the user.
Mm-hmm.
Well,
That's what he said.
yeah, and there you go again. I mean, somebody who's got a motive to fabricate is once again, filling
a criminal, a thief, a liar, all of the above, and he gets to be the one to give the testimony on that.
Right.
Okay.
Well, but the question is, how effective will the defense be in cross-examining?
Okay.
Instead to show that his testimony is isn't reliable. But then again, it gets over the jury. It gets overwhelmed. See, and this is where it comes down to why they want to use all this other stuff to dirty Kelly up with all these prior bad acts is because where you're saying, well, you got all these bad guys testifying against Kelly, and these guys all got problems with their testimony. And they're all con men and thieves. But Kelly's a bad guy, so we're gonna convict them. I mean, that's the way, unfortunately, that it works with a lot of juries. In this case, it's almost like I don't want to suggest anything to these guys, but to some extent, given the type of evidence that the government's trying to use, they may be better off just going with a bench trial to the judge. A judge is going to be able to, if she's a good judge, will be able to, just concentrate on what's reliable and relevant and what there's actual proof of and beyond a reasonable doubt, as opposed to juries which are sometimes swayed by emotion, a lot of times swayed by emotion. Maybe, but that's a in the federal system though, where in the state system in Illinois anyway, only the defense can choose whether or not it wants a jury. If the defense waives the jury, then they go to a bench trial. In the federal system, the government could demand a jury too. So maybe he can't get a bench trial even if he wanted one.
But it's easier to sway other people of 12 than one.
Yeah, but you're
one strong one person in there who's just gonna be like, no. Mm-mm.
Yeah, that happens. You get hung juries, but the government's got a 95% conviction rate, and
that's because they plea out.
No, I mean when they go to trial, they have a 95% conviction rate.
No, now based on what the judge says, it's only 3% conviction rate when they go to trial.
No way. No, I wish.
No, it's 3%.
3% conviction rate.
Conviction rate when they go to trial, but when they plead out, it's 95% plead out.
95% plea out, right?
Yeah.
But when the government goes to trial, They win
They don't-
they win almost all their cases. I promise you.
No,
Uh,
not with the judge. Not
Well,
with
then
the
she. I think
couple
it
of
might.
judges.
Well, I don't know. I didn't hear what she said, but I could.
No, a couple of judges said that. They said that that's why most of them take pleas because they don't like going to trial because they don't win most of the time.
Yeah, you don't win going to trial. You get a conviction if you go to trial with a jury in federal court most of the time. You know, but they, and they.
No, Joe.
Well, I'm telling you, you do. Yeah, you do.
Joe.
That's why people plea out, because if they go to trial, they're going to get convicted. That's why they plea.
No, that's not true.
Why do they plea? I don't know. I think you must have misheard. You can look it up, but people get convicted when they go to trial in federal court, almost all the time, and it's unfortunate. And that's because the government has an overwhelming amount of resources. You know, it's you know. Remember, I always used to say to the juries, I didn't do a lot of federal juries, but I've been mostly state juries. But when I would go to a federal jury, I would say, you know, here we are in the beautiful United States courthouse with the United States District Court judge and the United States attorney and poor schmuck defendant, you know, this poor little guy up against this massive government that has their big courthouse and their big U.S. attorney and their big federal judges. You know, that's one system, and the only hope that he's got is the jury. Because you know, it's really a massive amount of weight, massive amount of resources they have. It's very, very hard to win. I mean, you got to look at this case. Well, now that we know that they're throwing all this stuff at the last second that should have been done a long time ago, you just got to look at this thing in the big picture. And in the big picture, you know, it's got to be whether or not
Okay,
they believe it's a
right, Joe, hold on, I'm reading. It says currently federal prosecutors trial above 95% conviction rate. The primarily reason due to the fact that most cases never make it to trial.
No, they never make it to trial.
It said does not make it to trial.
Right, they plead out.
And it also said only 2%
go to trial.
No, go to trial, and only a small percentage is found guilty. That's what it's. I'm reading it right here.
Well, I mean, where are you reading that? Yes, you can. Okay. What percentage of federal cases that go to trial are not guilties? That's what you want to ask. Okay. What of federal criminal cases?
Trials.
Yeah. Mm-hmm. Criminal trials are not guilty. Are not guilty verdicts.
So only 5%.
Yeah, that's 5%.
That's very low. The one that goes to trial, only 5% wins. That's what it says.
Not here. For example, not guilty remains a rarity in federal and state courts. It's if you're. I mean, I'm telling you, if 98% of people that went to trial were found not guilty, everybody would go to trial. Okay, so it's if you go to most people that go to federal, that are charged with a federal trial, most of them, almost all of them are found guilty. They're going to trial is in federal court is they win most of their cases. Conviction rate here. Hold on, let me look at this.
It's right here.
I mean, I'm telling you, I did this for 37 years. I'm telling you, this is.
Did you do federal?
Yeah, I did federal and state. But look at here. Conviction
so you lost all of yours then, right?
No, everybody loses. Okay, United.
So you lost all of yours. I'm asking you, did you lose all of yours?
No, in state.
So then it.
But look, in federal court here, United States federal court system, the conviction rate rose from approximately 75% to approximately 85% between 72 and 92. For 2012, the U.S. Department of Justice reported a 93% conviction rate of cases that went to trial. I mean, this is this. I tell you, if you go to trial in federal court, 93% of the time you're going to be convicted. That's the rate that they have. It's unfortunate, but that's how it is. And they, in state court, it's different. In state court, we're probably around 60-40. But in federal court, they have an amazing amount of conviction rate. It's just, it's because they have such there's such resources that it's really hard. Yeah, it gets with the statistics you're looking at get mixed up between the amount that plead guilty and the amount that actually go to trial and win. I mean, I know there's a guy, Joe Lopez, that does almost exclusively federal trials. He has over 200 federal jury trials in the last over the last 35 years, and Joe's won, I think, 9 or 10. And he's considered one of the most winningest lawyers over there. They just don't win a lot, unfortunately. But let's yeah, most defendants here. I mean, I'm looking at this article here. Most defendants who did go to trial, meanwhile, were found guilty either by a judge or a jury. Yeah. It's just the statistics are against you. But and then they give you let me see where I'm looking for an absolute number here, but I think it's like 90, something like well over 90%. That's for sure. But at least.
Okay, you ready for the next question?
Yeah. Go ahead. Go.
All right.
Okay,
next question says the defense.
Oh, I'm sorry. Here it is. Went to trial. 80. Here's they're looking for. This is figures from 2018. Went to trial. 83% conviction rate in federal court. 83%.
83%.
Yep.
So that changed from that 90% that you said, right?
Yeah. Well, 98. Yeah. Well, I mean, 7% less. That's maybe they had a bad year, but 83% is
okay. Let's get what it is now. It's 2019.
Yeah, 20. That was 2018. So I don't know what it was, but 83% is still pretty damn good conviction rate. Let me tell you.
All right, you ready for the
sure.
next question? Okay.
Go ahead.
Next question says, can a defense use witnesses who Tasha K interviewed who alleged the crisis manager scammed out of money?
Well, that you're talking about impeachment by collateral. Yeah, they can. If they ask the guy, did you scam so and so out of money? And if he says no, then you can bring in the person that he scammed to prove that he's lying. Mm-hmm. That's okay. That's but generally what the government's not stupid. So what they'll tell him to do is, if you get asked that question, admit that you scammed the guy, because then what the government will do is argue, hey, here's the guy. He admitted when he committed a crime. We should, he's being honest with us. So believe him when he, they're not. It's not like you're going to catch the government by surprise in it. So they'll tell him. They'll tell him that if they ask you if you scammed just one person or you scammed another person, admit it, because then we could say that you're being honest and you're coming clean, and that's what they do. So they're prepared for that, unfortunately, but they are. They're
if they're using people like con artists and things like that,
right.
I mean, the majority of the people that they're testifying have criminal records.
Yeah.
Well,
that's
not going to be, huh? Okay.
That's what you can use that to impeach the witness to something, depending on the crime. It's got to be a crime of moral turpitude, like a fraud or a scam or a theft.
Mhm.
But, um, but the government, what they'll do is, if they know that witness has a problem, they'll front it. They'll ask that the government, when they put
But that's
them
why
on
they're
this,
giving them so much immunity. They're giving a lot of people immunity.
right, and what they'll do is they'll say to that person up front, the government, when they put them on the stand, say, you did this wrong and you committed this crime. They'll front it. They'll get it out of the way so that the defense can't surprise the jury and say, aha, he's a thief and a con man. They'll already know that from the government's own questioning. So that's called bursting the bubble or fronting the crime. And that's a technique that the government uses in order to try to diminish the impact of the fact that this guy's got a prior criminal record.
But what about the guy that the one I'm saying, the Demetrius guy?
Yeah,
He's
well,
in immunity, and he's a liar. He's a thief. He's this. He's that. He's this.
Well, exactly. Right,
So
but that's the whole purpose of doing the motions in limine early on. That's why you do those motions early on. So you get the judge to say that his testimony is not reliable enough for the jury to hear it. Because once it gets to the jury, the government's smart enough. They're very, very, very good lawyers. Very good lawyers. And the government's smart enough to be able to deal with that issue to the jury where it won't make that big an impact. So the secret is, and that's why you do it. That's why the trial is won and lost basically in the pretrial motions. And that's why you do these pretrial motions. So you get the judge to say, I'm not going to let this guy even talk to the jury because he's that unreliable. And his evidence is that full of garbage. And that's why you do it in these motions. Because once they get in front of the jury, you've already got a big problem. You have a big problem because the government knows how to deal with being able to deal with bad witnesses. You know, they say that they'll argue to the jury at the end. They'll say, hey, pedophiles don't hang around with priests and senators, and they hang around with other scum. So what do you expect to be the witnesses? We're gonna have to bring scum up because that's who he deals with. Gotcha. And they have the argument. They know how to deal with this. The way you do these cases is you knock out these witnesses way before trial, and by a series of motion after motion, challenging the witness and having hearings and limiting their testimony, narrowing their testimony, or knocking their testimony out completely as unreliable, and that's how you win the case. Because if they all get to the jury, if you get 100 if everybody's a really bad witness or a really thief, con man witness, but you got a dozen of them up there, at some point the jury's going to say, hey, everybody can't be lying. It's but if they only get one through that process of all the motions, one or two through the process, and that of all those motions you file, and by the time, and even those witnesses are limited in what they can testify to, then you got a shot. And that's why you do it that way. And that's why I remember talking to you, about a month and a half ago, when I first saw the docket sheet, and I saw that nothing had been done, and I literally fell off my chair. I couldn't believe it. I said, "Oh my God, this is a disaster." And then when I found out from Tom, how they've been limited and what they were able to do, I think during one of the last hearing that Greenberg was at, where he was complaining about his reputation being sullied. His reputation being sullied. That's a joke. The Farinella had written a letter to the judge detailing how obstructionist Greenberg had been. And when I went back and I heard that, and then
but she knocked it down. She said she don't want to hear the.
Well, she doesn't want to hear it, but she was also amazed at what had occurred. That he really did that. That she was amazed that he had done that.
But she also said that if all of this happened before, why didn't you guys
say anything? And that's when Farinella said that I can prove that he did everything like this. I can prove it. I have the evidence to prove it.
And then she said, "No, she don't want to hear all that."
Yeah, well, that's true though. I mean, she says, "Okay, he's gone," and it's true that Farinella. I mean, it's true that well, you have a choice, and when you're in a place like Natalie and Tom, you have two choices. You could throw your hat.
Nicole, not Natalie.
No, Natalie. I'm sorry, Nicole,
not
Nicole.
Natalie.
I don't like calling her by her first name because I really don't know. It's Farinella and Becker, right? Her last name is Becker.
Becker.
Yeah. They have two things they can do. They can resign. They can withdraw and say, "Look, we're being judged. We're being stymied. We're not being allowed to do what we think is the right thing to do, and we have to resign because we can't be stymied." And then the guy's left in Greenberg's hands alone, which is a disaster.
Well, but Greenberg's not there anymore. So
yeah, but there's no time. She's saying, "Why didn't you tell me about this a year ago?"
Yeah.
That's what the judge was saying. And the problem is that the other choice that they had was to stay in there and try to get as much positive done as they can, and to try to stick it out. And try to help the guy as much as they try to help their client as much as they can.
She also said that they were there from the beginning, so therefore, why didn't you guys do something then?
Well, no, because Greenberg was there from the beginning too, and Greenberg didn't let them do it. He has evidence of, how they stopped him, how Greenberg stopped them from doing it. I don't know the details of it. I haven't seen it, but that's what he told me. So, he had some sort of authority somehow to stop them, and impede them in doing it. And, it just, at some point, Kelly woke up and when he fired him, but, it was a little bit late, unfortunately. I know what Greenberg does, because as I said, he did this in the Peterson case. He had him convinced that if he after the trial, that if he fired me and used the ineffective assistance argument, that he would be home inside of a year. And now the Illinois Appellate Court, the Illinois Supreme Court, and the Federal Court, Northern District of Illinois, have all said that there was no ineffective assistance. As a matter of fact, that the team that I put together didn't really make any substantial errors. So, but he had him convinced. He conned him. He's a convincing liar, and unfortunately, his clients paid a price for it.
All right, you ready for the next question?
Sure, shoot.
It says, if the court didn't catch the fake ID, how is it Mr. Kelly supposed to know it's a fake ID?
Yeah, it's a good question. The question is, your belief as to the age in a statutory rape case. If somebody has a reasonable belief that the person they're engaging with is of age, then it's not a crime. And if a person has a convincing ID, then you don't have the intent necessary to commit statutory rape. So yeah, I mean that's a very good point. Which is, the court didn't get it, but then again, if they didn't use RICO, and this was just your classic, statutory rape, sexual assault case, it would be a very much simpler case. Did you think she was over 18? Yes. Why? She showed me an ID. Did it look good? It was a very perfect ID. I've seen hundreds of them. It was a really good ID. And how did she look? She looked mature. She had everything that a woman over 18 has. She had. That would be a very simple statutory rape case. But when you make it a RICO case, it becomes something totally different. And that's what's happening here. And it's really
a copy of the ID, and he brings it, and it comes to the court. So what happens with that?
Well, you could use that, but the problem is that it's really, when you put it in the context of a RICO case, a racketeering case, then it all of a sudden it's not as devastating to their case. It's not as relevant, because if you the crime is not statutory rape. The crime is violation of the of running a racketeering organization. In running a racketeering organization, you committed a minimum of 2 violations of law, of federal criminal law. So, so you got to remember that. Well, okay, the had an ID, and maybe it was reasonable, maybe it wasn't, but we're not looking at the act of statutory rape. We're looking at being guilty of running a racketeering enterprise, a RICO enterprise.
Have you ever did a racketeering case?
Yes, I've done one racketeering case. Yeah.
You had one racketeering. So what was the outcome of that?
Guilty. I mean, they're almost all guilty because they bring.
What was it? What kind of was it? Mafia related or what?
No, it was these guys had a really big. You know what link fraud is? It used to be called food stamp fraud, but now it's link fraud. They're running a multi-billion-dollar link fraud scam. Yeah, they had a number of grocery stores, and they were really making big bank, and so they came at them as a RICO enterprise, and everything that they ever did.
So how many people was that? Was it just one person?
2 guys, two brothers.
It's just 2 guys. So they did a RICO with 2 people.
Yeah.
So RICO could be with just one person then too?
RICO, well, it's not one person because he runs. They're showing that these other players involved were members of the RICO organization, like the crisis manager and the other people.
Yeah, but it's only one person that's being arrested on this one.
Right. They don't have to charge everybody, but those guys are in the racketeering enterprise, and what you're being found guilty of is not the act of the statutory rape, but you're being charged with running the racketeering enterprise that commits these crimes. And so that's what makes the whole thing about the fake IDs and everything less relevant to the charge. Because what they're trying to prove is that he ran the racketeering enterprise for the purpose of getting underage girls. And so even if he had an ID a good ID for one underage girl, that doesn't mean he wasn't running the enterprise. You see?
So how can they prove he was running an enterprise?
Well, with all this prior other bad act evidence that they're bringing in, that's the enterprise, and that's what makes RICO so dangerous for your run-of-the-mill, state court, crime, sexual assault or rape or armed robbery, car theft, carjacking. It makes it very, very dangerous to use it in that context because you can bring in all this other evidence, and you could, and you say, here, this guy and his friends were running this enterprise, and they're guilty of running this enterprise, and here's a bunch of crimes that they committed, and whether or not they committed them, maybe, but we got 10 of them here, or 15 or 20 of them, and they were looking for, in Kelly's case, they're looking for underage girls, and maybe they found them sometimes, and maybe didn't find them the other time, but the purpose of the enterprise was to commit crimes or do illegal things, and so if you convict him of that, then he's guilty, and that's it. And it's a very, very, by the way, it's an extremely complex federal criminal statute, but it's extremely powerful. It's extremely dangerous, and when they use it outside what it was intended, which was to go after the mafia families, it can be very, very unfair, and it really shouldn't be used in this case.
In the case, like with someone who's just doing entertainment, he's a singer. He's known for being a singer, and he has all this proof of him singing. There's no intention of
underage girls. Yeah, I understand. Yeah,
and
that's the problem. This is why they should have been attacking from day one the use of the RICO statute, and they did, and they weren't allowed to because Farinella says that Greenberg wouldn't allow them to, and that's held them back from doing it. And now it's too late.
They have to prove what the whole intent. There was no intent of any kind of
but that becomes less and less relevant because the intent doesn't got to be to commit statutory rape. the intent's got to be to run the racketeering enterprise to find the young girls. So it's a different.
So for them to go out and find that, but they have to prove that they were going out to find the young girls.
Yep. And that's where the testimony
and that's where the testimony of those other people will come in.
Bingo.
Saying that, okay, I got you.
Yeah. And that's it's a complex concept because it doesn't sound like it doesn't sound like, you'd think in a criminal case they got to prove that you committed the
crime,
the act, the criminal act.
Mm-hmm.
But you got to remember that the criminal act that they're proving is different than the traditional criminal act.
They're saying that he asked them to go and get that person.
Let's put it this way. Let me give you an example for it. I mean, it'd be an extreme example, but a very, very extreme example. But let's first say that I got together. You got together 5 guys, and you can say, "Hey, we're going to go out there, and we're forming, this crew. We're going to, call it whatever you want, Bob's crew, and we're going to go out. We're going to do carjackings, and we're going to get, carjack all these cars and make money selling them for parts. And you go out there, and you guys go out there, and they don't commit one successful carjacking. They try 100 of them. They're the Keystone Cops. They screw up every carjacking they intend.
Mm-hmm.
They're still guilty of a racketeering violation because they formed the criminal enterprise and they attempted to do the carjackings.
Okay.
So following through and committing the crime isn't 100% necessary.
Right.
Okay.
So for it to be a racketeering, RICO, it has to be an enterprise, meaning that it can't just be one situation. It has to be a multiple situation.
Right. At least 2.
At least 2.
Yeah.
Okay. All right. Next question is, if they never signed the marriage certificate, that marriage never happened and is invalid, which will be nullified in the event.
Yeah, that was it. Yeah. I mean, right. But did they try? You know what I'm saying? And that's the attempt. That's the question. Did they try to get the marriage certificate? If he didn't sign it, but did they get it? And was the purpose of getting it so he can engage in the sex act with an underage girl? Okay. So once again, it comes back to the enterprise and the RICO, and not the actual act of marrying an underage girl. So it's and this is why the government is gone this way, because they realize they're not stupid. They realize that they would have a problem, proving each individual crime if they were going to convict them of the crimes.
That's why they did
why they did it this way. But they shouldn't be allowed to, because RICO was not designed for this. Okay. RICO was designed to get the Gambinos and the Bananos and
also the case like you did with the fraud. That was more of.
Well, that was more. Yeah, I mean, these guys there was 2 guys, and they were in a mafia family to some extent, but it was more in line with what a RICO would have been. Yeah. And then a criminal enterprise. It was a financial criminal enterprise. But not when you're taking traditional state court. Your basic state court, your state offenses, which are the violent crimes and misdemeanors. The everyday offenses. And turn them into RICOs, and that's that would have been a great motion. That would have been if they had brought that motion and briefed it and really did a good job on it. That would have been a great motion to bring, but it's too late.
Yeah.
Now the thing that they have though that they can do, and this is, you got to remember something too.
Mm-hmm.
These guys. And I'm not advising anybody. So
no advising here, just your opinion.
Right, I'm not advising anybody what to do. But
I'm not a lawyer, so it's not like you could advise me anyway.
Well, yeah, and you're not in trouble either. But what I'm saying is this: they have to make a very, very good record, because just because you lose a trial doesn't mean you can't win on appeal. And if you can even just challenge in some way the use of the RICO statute to preserve the issue for appeal, and you can preserve the ineffective assistance of Greenberg for the last 2 years and preserve it for appeal and make a good record about it, then if he's convicted, you can bring all these issues up in the appellate court. Okay. And there was a guy in the what was his name? I forgot his name right now. But he was a federal criminal guy, and he did a lot of mobster cases. But he never won a federal. Like I said, you only win 6% of them. But he never really won a federal criminal trial. But he made such great records that when they went up on appeal, his reversal rate was almost 1/3. So he was able to make such a really good record at trial on really good issues that 1/3 of his cases got overturned, of the convictions got overturned on appeal. So hopefully these guys are also, while they're trying to win the case, obviously, are also focusing on making a really good record for an appeal. It took Cosby 3-4 years to get out.
Yeah, hold on. It's not 4. It wasn't even 3 years yet.
3 years? Okay, great.
It wasn't 3 years. Hey, Spitting Fire, I just put the link. Check your text message. All right, I'm sorry.
Well, it's okay. But not even 3 years. But I mean, 3 years in jail is not pleasant. But he's a. Ask Joel. Hey, I'm looking at this. Ask Joel, do you think it's suspicious that Steve tweeted Avenatti a year prior to becoming charged? Yeah. Well, I think that Steve Greenberg and Avenatti are two peas in a pod. So, so the fact that Avenatti and Greenberg are talking to each other is, makes sense because they're both, don't care about their clients. It's. But if they make a good record on appeal, even on the ineffective assistance part of it, and some of that stuff's in the record and sealed right now. Like I know that the letters that they've written that outline a lot of what happened. If they make a good record on appeal, just because you lose a trial doesn't mean you're going to lose on appeal. And it's really important that they do that and have a good record for appeal. So, a lot of, the appellate courts exist to reverse trial courts. That's their whole purpose. So, so if you didn't have convictions, appellate courts wouldn't have much to do. So, if you got, you got to sometimes focus on trying to win the case, but also making a really good record. So when there's that review on appeal, then you have a really decent shot at getting the case reversed.
But then that looks bad on the judge.
Well, the judge is, the judge can only do what the judge can do. In this case, a guy's been in jail for 2 years. There's the government and the defendant have a right to a speedy trial. So, she's got to get the trial going. What was she going to do? Even if she delayed this case, she couldn't delay it more than 30 days. It's been over 2 years. Yeah. So, it's got to go to trial. I once had a case with
something. They asked me about the Rand Paul. The Senate introduces amendment to protect against infinite detention. What do you know?
Indefinite detention. Yeah. Is that focused on the Guantanamo guys? I know that there's a really big problem with with this pandemic. There's guys that have been sitting in jail who without being able to get to trial, who if they were convicted wouldn't have spent as much time as they did in trial. If they had gone in there and been convicted and sentenced at a maximum, would be out. But they can't get to trial. And that's just wrong.
Hold on, we only got 1 second. Then we only got 71 likes in the chat, and there's over 311 people.
Oh, come on! How am I gonna get my blue check on Twitter? Come on.
What is wrong with these people? They want to suck you dry, but don't want to hit the like button. You know what, Joe? I think you probably need to stop talking until these people get these likes up because it's not fair.
We got the algorithm.
It's not fair because we could go and have a conversation behind the scene, Since these people don't want to hit the like button, they want to.
Well, I think they want to hear that Kelly's got it. I'm not gonna. One of the reasons maybe one of the reasons that I got in trouble is because I call it like I see it and I don't sugarcoat.
Mm-hmm.
And that's not very politic, but that's just the way I am. And I mean, I'm really sorry but this is happening to Kelly. I really, really am. I mean, but it did what they've set things up that just doesn't look good. I mean, a lot of things that could have been done, that I think that weren't done, and now he's in a very bad position, and his lawyers are going to be fighting like hell, and trying to win a trial, and then also trying to make a record for a good appeal if he's convicted. But it's it doesn't look good, and it's not his fault, and it's not Nicole or Tom's or these other two new guys' fault. But it is what it is, and you can't avoid that. I once had a guy represented. It was a attempted murder charge, and his case against him was it was strong, but it wasn't the best case. But he kept putting it off for like 6 years. He was in jail 6 years. He just never wanted to go to trial. And finally, I just told him, "Hey, man, it's got to end sometime. You can't put it off forever. You got it's." You just got it. Sometimes it's got to end, and I wish it didn't happen this way to Kelly. I really, really, really did. It's really for a man with his resources. I mean, it's an extra shame, but it is what it is. I'm really sorry. I hope that one thing I'll give everybody some hope. That with juries, you never know. I've seen juries where there have been cases where literally everybody was, juries that came back not guilty when everybody thought it was going to be a guilty, and then they come back in 45 minutes and it's a not guilty, and everybody is, the judge, the defense, the prosecutor, everybody's amazed. You just never know. And I've also seen cases where everybody thought it was going to be a not guilty, and the jury comes back guilty. I mean, juries can do very strange things, and you just never know. And there's always a possibility that it's not impossible that he wins. It can happen. So and especially if sometimes the government makes a mistake, or they seem too overbearing, where the jury says, this just isn't fair, and they tend to side with the defendant. That happens, and maybe that's what's going to happen here. They'll see so overwhelming that they're so overbearing on the defense that the jury's going to say, hey, this just doesn't look right. This isn't fair, and he'll quit the guy. For simply that reason, they'll ignore everything that they heard and they'll say, this is just unfair, and they'll acquit him. And I've seen that happen. So you never know.
What, Joe, I'm going to end this because they're not putting the lights up.
I'm sorry. I hope it's not. I hope it's not
you. It's them, because they could come in here and they're not being right. That's not fair to me, because I invited you as a guest, and I have people coming in as guests, but they want to suck up information and they don't want to hit the like. So I can say goodnight.
Is it? I don't even know how this stuff. I'm an old timer. I don't know how this.
I know, but
algorithm stuff works.
Fair to me. It's not fair to me. It's not fair to you that you're taking up so much time.
I love talking.
We have over 300 people. We have 300 something people in here, and we can't get the likes up. That's not right.
Well, maybe 150 of them are Greenberg and it was fake accounts.
But it's not fair to me, because what I'm saying, I took the time out reaching out to you, reaching out to different attorneys and things like that, but they don't want to show appreciation. I'm not asking them for money. I just ask them to participate. So let me see. How do I get hit the like button? Amazing. How you hit the like button? You just
is this on YouTube? Right. YouTube.
It's on YouTube. Yeah, it's on YouTube.
Okay, well, I gotta go on the YouTube channel and do it.
But fair is fair, because you got 300 something people in the chat, but nobody wants to hit the like. That's not right to me,
Well, I'm sorry. I enjoy talking about the law, so I enjoy myself.
And I appreciate you too. I really do. But it's just not fair that these people in here and they can't hit the like. And I mean, fair is fair. Fair is fair.
Okay. All right. Well, in any event,
Okay, I'm going to invite my sister. She's coming in right now. Hold on a second.
okay.
There she is. Her name is Spitting Fire.
Hey, what's going on, y'all?
Okay.
Hi, how you doing?
Spitfire. Okay.
Oh, good. I'm good. Everybody all right today? I am so sorry. I was in the car listening to you guys, and I was driving. And when you said I got the link, I was like, I'm on my way home. I'll be there in 5 minutes. Or whatever. I was listening to all the questions and the answers to a lot of things or whatever. And everybody was concerned about this R. Kelly situation, I know, and the cases and stuff like that. And basically what it all boils down to is everybody's talking about the federal government and all this and that. But, there are people too. They make mistakes as well.
Yep.
And the fact of the matter is it depends on if they have a strong enough case. Now, I know that you said that they have a high conviction rate, which they do. And a lot of it is for pleading out. And then even if they do go to trial, they don't have a bad conviction rate. But it also depends on the attorney and the attorney experience. And also depends on the popularity of the case as well. You know what I mean? Because like you can have a person that's had a case, as you mentioned, but then you never had a person who was high profile as well, like Robert Sylvester Kelly.
Well, I had one guy was pretty high. Well, I've had two high profiles. One was Drew Peterson, which got the Bolingbrook, Illinois cop that killed his third and allegedly fourth wife, and yeah, he's almost like Henry VIII, right? And then the other guy was Robert Rialmo, who was a officer involved shooting in in Chicago, the first one after Laquan McDonald.
Well, yeah, but when I mean high profile case, I understand about that.
An entertainment case, in entertainment.
Yeah, but entertainment that is worldwide, like he is.
Yeah,
itself.
When you mix Hollywood and a criminal case, it's something. Yeah, it really takes off.
So you have the United States government going against someone that's really huge. You know what I mean? And things like that. So you got a lot. It's a lot playing against this. Now the government is going, like you said, they're going to try to, pull out people's imperfections, or you say prior bad acts, or witnesses, or criminal records before the defendant can't. But what they're going to do is they're going to make it worse than what it is, because you got to think of like this. You got to think of the jury. Like, if I always think of things if it was me, you know what I mean? I look at it as me being a citizen, as me being on the jury, and bias free, I may add, because when I decided to talk on Robert Sylvester Kelly case, I looked at everything not as a fan, because I wasn't a fan of his, but I looked at everything as if I was a juror, and I've always tried to follow what the law says and how it's going to be upheld. Unfortunately, a lot of people convict on emotion, but if you can tap into the doubts of the people, because the one thing I've learned about people do not like to be lied to. That's true. If these people come, because if you really think about the juror from the last trial, one of the reasons why the people found him not guilty, not in addition to them not being credible and that the judge had to throw out someone for perjury, but the fact is the behavior of them. So because the image and speaking is two different things. If you got people on social media saying something totally different than what it is they told the prosecutor, even if they did a criminal act, and then you still come out here lying and you still out here doing anything, that's not going to look good in my eye. Because if I'm a juror and I
can see why I call her Spitting Fire.
Well, here's the thing. No, because that's right. But listen, here's the thing. If I'm a juror, and if you are the prosecutor and you tell me that everybody that you have has a criminal record, it doesn't matter if you sit up there and call them out and let me know that they have a criminal record first. I want to see somebody who was average and who was damaged. Because to me, as a person have a criminal record, I'm going to think that they have some vendetta against the person who they used to work for. See, you can't be a surface level thinker on here and see that's what the defense going to have to do. They have to make sure that they don't pick surface level thinkers when they want people to be a juror on this case.
Spitting Fire. Let me tell you, there's two things. in this case, you're going to know when the judge rules on these motions and limines before they start, right around the time they start picking the jury, August 8th, you're going to be able to tell a lot about how this case is going to go by how she rules on these motions. Because if she, they're trying to keep a lot of these, criminal history of these people out and their prior bad act and their inconsistent statements. The government's trying to keep it out. And if the judge allows the government to keep it out, keep it away from the jury, then you know what time it is. The other thing is you're 100% right, and everybody that's listening is going to be at some point summoned to be on jury duty. And when you're summoned to be on jury duty, remember, hold the government, the state, I don't care if it's state government or federal government, whatever it is, hold them to their burden of proof. Make them prove the crime happened and this person did it, the defendant did it, beyond a reasonable doubt. And if you hold the government, there'll be a hell of a lot less wrongful convictions if jurors would just hold the government to their burden of proof. And it's really, that's why being a juror is probably the most important thing that somebody can do, because you got somebody else's life in your hand. And you got to remember that whenever you're on a jury, and you will all get summoned at some point in time in your lives. You'll all get summoned to be on jury duty. Hold the government to their burden. Don't just go along, and say, well, that prosecutor, is a nice guy, and this guy looks really like a gangster, and I'm going to throw him in jail. No, make them prove it by facts beyond a reasonable doubt. And if you do that, the system works, and hopefully that's what I said. Who knows in this case? Whatever all the government's efforts.
See, that's exactly what I'm saying, because I'm thinking of myself as a juror, and I'm thinking to myself, immunity for some people to testify against, yeah. But when you have multiple people
when everybody's got immunity, yeah.
Yeah, I'm gonna think different than that. Now I'm not gonna think the same way. Now everybody ain't gonna be thinking and scared of the United States government, because for one, people ain't happy with the politicians anyway. So people are not scared of the federal government like they used to be. So let's get that understood.
I'm terrified of it.
I pay federal taxes. I am not. I promise you, I'm not. And as long as I pay my tax money and I want it to be used in the right context in which they should be using it, because they done effed up enough of our damn money. See, the problem is that the people forgot that they work for us and we don't work for them, and that's the problem.
Yep, that's 100%
I'm the one. I'm the right one. I
want you in my jury. Next time, if I ever start doing this again,
you're damn right, and you gonna want me as your attorney too, because I know a little bit of law myself. So I'm gonna tell you that stuff. Some of that stuff that you spewing ain't right today, because people ain't scared of the federal government like they used to be.
I hope you're right.
I know I'm right. Let me tell you something else. Because if I wasn't right, I wouldn't have been right about the stuff that I was saying all along. I knew that these people and the scandal behind it, I knew what was going to happen when it happened. I said it from 2019 to 2020. And every time I'm on somebody's channel, they tell you Spitting Fire was right. You was right about this. Because I know what I'm talking about. You can't be a surface level thinker. And see, we got to change these laws to people, because if we don't change these laws, these people go do what they want to do. The problem is that they have these liberations movements inserting themselves in our democracy, which it ain't supposed to be there. That's the problem.
Yeah, you know what? I'll tell you. Did you know what they did to? I was, and I said I'm scared. They frighten the federal government. Frightens me. Did you see what they did to General Flynn? General Flynn was the head of the Defense Intelligence Agency. I mean, that's a big and very powerful intelligence agency. And they talk about the deep state. Well, that's like being one of the chiefs of the deep state. And and then the FBI went to him, and he made some. It didn't even really lie. He said, they asked him, did you tell this guy X, Y, and Z? And he said, well, you got the tapes. You're the government. You got the NSA. You got the tapes. I don't remember saying that way, but you got the tapes. And for that, then what they did is they indicted him for lying to the FBI, which wasn't really a lie. And then then when he wasn't going to plead guilty, they told him that unless you plead guilty, we're going to indict your son. Well, what father wouldn't, take a bullet for his son? So he said, okay, leave my son alone and I'll plead guilty. And then, thank God that, they eventually, the truth came out and the government, he actually had to get a pardon to get out of it. They wouldn't even, the justices, the feds, the justices, they wouldn't even let the U.S. attorney drop the charges, for God's sake. They still tried to get him. The government, when they want to come after you to get you for purely political reasons, and what they did to that man, was really, and though people say now he's become radicalized. Well, who wouldn't become a little bit radicalized if the government did that to them? It's a very, very powerful tool. The government's ability to prosecute and put people in jail is an extremely powerful weapon they have. And if you have unscrupulous people, wielding that weapon, the
government in this case is weak as fuck.
Well, I hope you're right, because
it's weak. It's weak when you have to sit up there and put anybody that's in a documentary and you're in motion and all this and that. It's weak. It's weak as hell, and it ain't got nothing to do with them being powerful. They only as powerful as you allow them to be.
Yes, well, that's the point, because they need the jury.
They need the jury, and not only that, we are the people. Right. We are it. So don't feel that they ain't no better than, they ain't no stronger than what we allow them to be.
Exactly.
Because if we as people raise our voices and we sit up there and because I know that this is some BS. All right, you sitting up there and all these people got criminal records. You gave all them indictments, and then all of a sudden you want to add some uncharged prior bad acts. This the same type of S that Bill Cosby got his stuff overturned. Right. And that was on a state case. So what you think that's going to happen on the federal case as well? It ain't too much difference.
Well, it's like you said, it's all up to the jury. The government, with the one protection they have, the protection people have against this powerful weapon the government has is 12 citizens on a jury. And if 12 people on a jury can see their way to the truth, then you're right, the government's powerless. And that's the key. And that's why I say, being on a jury is it's not an inconvenience. People want to get out of jury duty. Nope. This is if you want to be free, you got to go to that jury and you got to hold the government to its burden of proving it happened beyond a reasonable doubt with no bullshit evidence.
You do. And a good thing about it, and if you can't come at me being a juror and you got a whole bunch of criminals, because one of the things that I'm going to think, but let me explain this. Now, one of the things that I'm going to be thinking about, if you're saying it's an enterprise, right? Mm-hmm. So if you're saying this is an enterprise and you giving everybody immunity, there's nobody else because you want this man. See, I'm not stupid. I'm going to think something is up with this. Like, why is it that he's the golden goose? Because he's the big celebrity. Right. You get what I'm saying? Yeah. So people think like that. Well, people think like that, and don't let it be somebody who graduated on "I Believe I Can Fly," and that was their graduation song.
I'm not on the jury, by the way. You don't have to get mad at me.
No, I'm just saying. I'm just letting you know because you was talking some crazy mess before I came on here. I just wanted to get you straight and get you together. What I wanted to say
nothing would make me happier than a jury who saw the government can't convict somebody in a RICO and being in an enterprise where they give everybody else immunity and only have one person there. That doesn't sound like an enterprise to me. So
that doesn't. And it's gonna be a lot of smart people. And if the defendant asks the right questions, they can get some right people as well. So it's not just one-sided with the FBI. That's all I wanted to say. Thank you so much. It was nice meeting you, Mr. Brodsky.
You're welcome.
It was nice meeting you having me on your channel.
That's okay. I never want to get into a fight with you, so that's okay.
No, you don't. Fire out.
Okay. Take care. Oh, that's your sister, huh? Must have been some interesting Thanksgiving dinner or something. Anyway, all right. Well, look it's how long time is it? Wow. Oh, geez, 9:40. All right. But anyway, it was a pleasure talking to you. I hope we'll be talking again before August 8th. I think.
Yes, definitely. Thank you.
I'm going to start paying. No, my pleasure. I'm going to start paying. I kind of wasn't watching the docket there for a couple of weeks because doing some other stuff. But I think I'm going to start keeping track of what the doc is. I'm really going to be interested to see the response that they're going to be filing to these motions.
Yeah, they have until the 30th to oppose.
So I want to make sure I look at those and see what I think. I'm sure these guys are probably working literally 25 hours a day, and hopefully they do a quality, hit all the right points and get a judge who's not afraid to make the right rulings and try to get this guy at least a fair trial. This should not. The only thing I can say about this case in closing, it should not be in federal court. These are all state court crimes, and they should not be in federal court. It should not be a RICO case, and it's it's the reason they went this route is because I think, because looking at the evidence, that they would have a hell of a hard time proving a lot of these charges in state court. So, but
Joel, thank you so much. I appreciate you coming on the board, and I'm gonna tell you one thing: the next time you come and these people don't hit the likes, I'm cutting it off.
Okay.
Serious. I'm not.
All right. And tell them to help me get a blue check on my Twitter.
Yes, he wants to get a blue check, y'all.
That's all my goal.
Get a blue check.
My goal in life. All right.
Get a blue check.
I'll talk to you later.
Thank you again. Have a good night. Okay.
You too, dear. Bye.
All right. Have a good night. All right, guys. Again, here's the rules. If you can't hit the like button when you're in here, I'm not gonna have any more guests. That's it. It's not fair to me. It's not fair at all. It's not fair to my guests that you guys just sit here and you suck up, and that's selfish. You need to start to give. All I ask you for is a like. But no, I had to pull teeth and nails and all that kind of stuff. I won't do it anymore. I was gonna bring a couple of more attorneys, judges, and things like that. But no, y'all want to be selfish? I'm going to be selfish too. You don't appreciate me? I'm not going to appreciate you by giving you all this stuff. So on that note, you guys have a good night. You really pissed me off tonight, but good night.